Professor Kiblagat, Vice Chancellor of Kabarak University, Dr. Korir Songoy, Principal Secretary, State Department for Foreign Affairs, my honorable colleague, Justice Febe Okowe of the International Court of Justice, Honorable Commissioner Sarah Bonaya, Deputy Vice Chancellors, Justices, Professors, all protocol is observed. Ladies and gentlemen, good afternoon. It is a great honor and a privilege for me to have been asked to deliver this inaugural lecture in honor of Dr. Bonaya Godana. I thank the Vice Chancellor, and I also thank Professor Humphrey Sipala, who was behind this initiative of the distinguished lecturers. And of course, I thank the law faculty of the University of Kabarak. I wish to commend the University of Kabarak and its law school for establishing this distinguished lecture series in honor of Dr. Bonaya Godana. In Africa, we do not celebrate and honor enough our scholars and our statesmen. Actually, in our schools, we talk mostly about foreign scholars and foreign statesmen, not our own. And therefore, it is really to the honor of the University of Kabarak to have instituted this series of distinguished lectures in honor of a great, not only Kenyan, but African scholar and statesman in the person of Dr. Bonaya Godana. I met Dr. Bonaya Godana in Geneva while he was pursuing his doctorate. I was also there studying for my doctorate, but I arrived at the Graduate Institute of International Studies a year earlier. So as a brother who joined me there, he immediately sought my advice on a number of challenges, which of course, young scholars from Africa face it when they go abroad to institutions of education with which they are not very familiar. The first challenge was that neither of us had anticipated that the institute we were admitted to and where we wanted to do our doctorate was bilingual. But neither of us had a satisfactory knowledge of French when we arrived. So his first question to me was, how did you deal with this? Because in the doctoral seminaries, all students were expected to understand and to follow the discussions in English and French, in both languages. And all the professors were bilingual. I told him, you must immediately enroll in intensive French classes. And he did, and he excelled, I can tell you that. A second question which he asked me, which surprised me to a certain extent, was, did you learn skiing? And I said, no, I haven't learned skiing. And he said, perhaps we can learn together. And we did that, actually, but he became a much better skier, especially downhill skier than I was. And he continued, whereas I stopped after a little while. But we also shared a lot of other adventures during those years in Geneva. But I wish to specifically mention one here, which is of interest to our lecture today. And that is the convening or hosting of informal debates and exchanges among Asian African doctoral students, which Dr. Godana called it the Bandung Group. He was the convener of the Bandung Group at the Graduate Institute. We all enjoyed this get-together in those heady days because we still firmly believe it as students, and students especially who came from the third world, that we could perhaps change the world and create a better international order than the one which had prevailed until that time. So he was a real tiers-mondiste, what we call it in French, a third world, a man from the third world. But he also was an intellectual who wanted to follow on the footsteps of the Bandung Declaration. This will be indeed the first axis of my speech today, the Bandung Declaration and the international rule of law. The second axis will be based on the vision and the kind of international lawyer and international law which Dr. Bonaya Godana was trying to promote and to put forward. The late lamented Italian international lawyer, Professor Antonio Cassese, categorized international lawyers as follows. He said that they are either intuitive or reflective, innovative or mainstream, technicians or investigators of overarching structure, geographers or explorers, and broad brush painters or meticulous polishers. I hope that you have taken note of these different categories of international lawyers. Those of you who knew Dr. Bonaya Godana will hopefully give some thought to these categories and determine in your own minds to which category he belonged. But I can tell you one thing. He was definitely an explorer as opposed to a geographer. And I will explain why. The metaphor of the geographer as opposed to the explorer finds its origin in the famous book of Antoine de Saint-Exupéry, Le Petit Prince, the Little Prince. Those of you who read Le Petit Prince or Little Prince will recall that during his journey, the prince encounters a geographer hunched over his desk, mapping his planet. He is too important and busy to leave his office in order to see the towns and rivers and mountains that he details on his maps. His brain is fixed on their identification, location, and description, and on mapping known territory. He's not interested in exploring the realms of the possible. By contrast to this geographer, Dr. Bonaya Godana was an explorer because he ventured into real life. His study and practice of the law was aimed at affecting and improving people's lives for the better. He wanted to explore how best the law should be used to improve living standards, to improve the quality of life of the people, to uplift the poor, and to bring about more equality among peoples and nations, and to ensure peace and the protection of our planet. To this end, he explored different aspects of the law, far and wide, in his research and writings. He then went into action as a politician in order to bring his ideas into life and ensure that they had a real impact on people's daily lives. This will be the second axis of my speech today, exploring the current state of the international rule of law and the need to stand up for it and to defend it against law breakers, as Dr. Godana would have done, to ensure equality among nations, to prevent a return to resource imperialism, conquest, and colonialism, and to bring peace and stability to the relations among states. Taking up the first axis of my lecture today, the question is, what was so special about Bandung in terms of international law? Because I don't think that this is taught in law schools in Africa, but this is really part of our history. This is really part of the African perspectives, not only African, but African-Asian perspectives of international law. All those nations that were excluded from the international legal order, that were not protected by international law, and that were actually oppressed, colonized, and enslaved for a long time, despite the fact that the Europeans claimed that there was international law and there were rules of international law. They were excluded from that. It was only after their independence and before the independence movement and through Bandung, which was a milestone in their emancipation, that they offered and put forward their views, their perspectives of international law and how they felt the international legal order and the international rule of law should be constructed and established in an equal manner, applicable in an equal manner to all peoples and nations of the world. So how did Bandung become such a historical event which inspired years later doctoral students from the global south in Geneva? What was the impact of the Bandung Declaration on the international rule of law? We need a little bit of historical context here. It should indeed be recalled that with the adoption of the United Nations Charter in 1945, an international legal order with a universal vocation was gradually emerging for the first time in human history. However, the rules and principles underlying this legal order had yet to be precisely elaborated and formulated. The Afro-Asian countries could not initially contribute to this because most of them were still subject to colonial domination. This situation changed with the Bandung Conference of 1955, where 29 African and Asian states met, representing 1.4 billion people, or 54% at the time of the world's population. A 10-point declaration on world peace and cooperation was adopted by the conference, and a declaration also on dependent territories, which in my view was groundbreaking and unprecedented in international law. Indeed, one of the historical and revolutionary statements which came out of Bandung and influenced the subsequent development of international law and international relations was the condemnation of colonialism in all its manifestations as an evil which should speedily be brought to an end. The outlawing of colonization in international relations and the proclamation of the right of all peoples to self-determination. A right to self-determination which the Bandung Principle is considered to be a prerequisite of the enjoyment of all fundamental human rights. The Bandung Conference further declared that the subjection of peoples to alien subjugation, domination, exploitation constitutes a denial of fundamental human rights, is contrary to the UN Charter, and is an impediment to the promotion of world peace and cooperation. It also called on all colonial powers at the time, which were still present in Africa and oppressing African peoples and in many Asian countries and Caribbean countries, to grant freedom and independence to all those colonized peoples. These were foundational principles and rules which gradually became part of international law but were initially rejected and opposed by the Western powers, as you can imagine. The Bandung participants also established in 1958 the Asian African Legal Consultative Committee, which later became an organization to facilitate interregional cooperation on international legal matters. It was the first time that these two continents, the peoples and states of these two continents, were working together to reform international law and to establish a more just and fair international legal order at the international level. The Bandung Principles were endorsed by the first Conference of Independent African States, which took place in Accra in 1958 and was attended by the first 8 independent African states: Ethiopia, Liberia, Egypt, Ghana, Libya, Morocco, Sudan, and Tunisia. These African countries declared their unswerving loyalty and adherence to the principles enunciated at the Bandung Conference in 1955 and instructed their permanent representatives to the UN to cooperate closely with the Asian countries on the future of decolonization in Africa and on all efforts aimed at bringing to an end colonialism in all its forms and manifestations. But the Bandung Conference was not only about putting an end to colonialism. It was also about establishing firmly and clearly the sovereignty of African states once they are independent with respect to their resources. Because one of the objectives and the reason is underlying colonization and colonialism was always the plundering and exploitation of the resources of the peoples of Africa and Asia. So what did they do? They promoted, first of all, in the United Nations, this famous, and I hope that most of you have heard about it, the famous Resolution 1514, which called for the right to independence of all colonial peoples and established it for the first time as part of customary international law, the right of peoples to self-determination. Indeed, the International Court of Justice, observed recently in a case that was brought before it, that the adoption of Resolution 1514 of 14 December 1960 represents a defining moment in the consolidation of state practice on decolonization, and the court continued. The court considers that although Resolution 1514 is formally a recommendation because it was adopted by the UN General Assembly, it has a declaratory character with regard to the right to self-determination as a customary norm in view of its content and the conditions of its adoption. So it had already made the right to self-determination as a norm which was part of customary international law. But they did not stop there. They also sponsored Resolution 1803, which made it clear that the permanent sovereignty over natural resources belongs to the people and not to the state, and therefore affirmed for the first time the right of peoples, or the sovereign right of peoples over their natural resources. This was also another unprecedented rule of international law, which was established thanks to the initiative of the Asian African countries, the Bandung Group, joined this time by the Latin American countries at the United Nations. And they did not stop there. They continued in 1970 with a new initiative to interpret the general principles of the Charter of the United Nations. Because you will recall that the Charter of the United Nations was actually crafted, it was elaborated at a time when most of these countries were still under the colonial yoke. And they could not have participated and contributed to the determination of the rules which will underlie the Charter of the United Nations. But the positive aspect of the Charter was that it included principles which could have been developed or which could be developed, which could be further elaborated, which could be interpreted actually, so as to accommodate many of the rules and principles and norms that the African and Asian countries wanted to be applied in international relations. And that is how they actually asked the General Assembly to adopt a declaration which became known as the Declaration on Friendly Relations Among Nations in 1970, and which was interpretative of the principles of the UN Charter and brought into reality some of the perspectives and views of Asian African countries on international law and on the international legal order. So this resolution, Resolution 2625, which incorporated the declaration, can be considered a milestone in the reform of the legal order which existed prior to the United Nations Charter and in strengthening of the principles of the UN Charter, taking into account the views and perspectives of the newly independent states. It consigned it to the dustbin of history, the old legal order, established in Europe in the 19th century, which allowed for the use of force to settle disputes, the conquest of foreign territories to plunder their resources, and the colonization of African and Asian territories and states, as well as the subjection of their peoples to foreign occupation and domination. And it is strengthening the prohibition of the use of force among states and in international relations, as opposed to the legal order which prevailed before. Now, the question arises, what has become of the international rule of law to which the Global South contributed so much through the Bandung Declaration and through the initiatives taken in the UN General Assembly, in codification conferences, and in other international fora, in order to reform and progressively develop international law as established under the Charter of the United Nations. I will try to address this question as the second and final axis of my speech today. We all know that every society needs, whether it is domestic society or the international society, needs to determine how the relations among its members are to be governed. So all societies establish rules and standards for that purpose. Of course, this applies to the international society, but we did not have a real organized international society before the United Nations was established. Because, as I said earlier, actually more than half of the nations of the world, more than half of the peoples of the world were still under colonization. So how could you have a society which had colonizers and colonized? It would be a totally unequal society, and a society which could not have rules and norms of law that would be applicable to all its members. So one had, of course, to wait for the decolonization process, for equal sovereignty and the principle of equal rights of peoples in the Charter to be developed in order to talk about a rule of law at the international level. And that is what practically emerged over the years as a result of the work at the United Nations and of the initiatives undertaken by the newly independent states. So, different options are available to an international society. States can respect and establish and respect a rule of law. But also, they may decide to settle and regulate their disputes through force. And that was the situation before the UN Charter. The use of force was legitimate, was considered legitimate in international relations. It's only with the Charter that the prohibition of the use of force has come into being. But what did this legitimization of the use of force lead to? What did it result in? It led to two destructive and catastrophic wars in Europe, which became world wars and which spread to the rest of the world in the first half of the 20th century, not to mention the numerous wars in Europe in the 19th century and the colonial wars in Africa and Asia, which resulted in the death of millions of people. This is what the lack of a rule of law leads to. This is what the lack of a prohibition of the use of force in the international society leads to. It leads to wars, it leads to violence, it leads to destruction and catastrophe. So in 1945, through the UN Charter, the founders of the UN chose the rule of law and rejected the rule of force which had hitherto prevailed. This choice did not come from nowhere and was not a sudden decision. It was a result of the evolution of human civilization. Humanity was becoming more polished. Humanity was becoming more civilized. It was a result of the realization that the old system, which had made war permissible to right wrongs, was not only brutal, but fundamentally unjust. Thus, the international rule of law is a recent human achievement and represents a model of an international order based on the rules of international law, as opposed to a model governed by the claims of power of a few states over all the other states. The old expression, might is right, has never helped humanity to live together in peace and harmony. So the emergence of an international rule of law in the second half of the 20th century and the underlying respect for the principles and rules of the UN Charter acted in the past 80 years as a bulwark against the widespread wars and violence in the world. Sovereign equality of states, equal rights and self-determination of peoples, the prohibition of the threat or use of force against the territorial integrity and sovereignty of other states, and the peaceful settlement of disputes, among others, are the fundamental principles and rules which brought us all peace and stability. They also served as an engine of freedom and emancipation for the peoples of Africa, Asia, and Caribbean from colonial rule, and enabled them to consolidate their independence through the elaboration in declarative UN resolutions such as Resolution 15, 14, and 26, 25 of rights and principles which legitimized, legalized their march towards independence and sovereignty. They also equally served as an engine of economic development and prosperity in many parts of the world, including Africa, but mostly in Europe, which enjoyed for the first time in the history of Europe, Europe enjoyed for the first time in its history an uninterrupted peace and stability for almost a century. And this is thanks to the international rule of law. And I hope that the Europeans who are not speaking against the use of force in international relations today will appreciate it. Because unless they speak about the use of force and against the use of force, they will also be victims tomorrow of such use of force. The embodiment of the rule of law in the UN Charter went hand in hand with a significant increase, not only in the rules applicable to the relations between states, but also to those applicable to individuals and those meant to facilitate the life of peoples when crossing borders for whatever reason or communicating with others outside their countries or continents. The increase was due to the conclusion of international agreements in a wide range of fields, from aviation to telecommunications, from labor standards to trade and investment, from human rights to humanitarian law, and all the way to environmental law, global warming, and the protection of biological diversity. It also gave rise to thousands of treaties, establishing cooperation among states, both at the bilateral and multilateral level. And that is exactly the spider web, as the deputy vice-chancellor called it, the spider web which, when put together, can tie down the lioness, and that is the spider web which underlies the rule of law at the international level. But we have to realize that 80 years is a very short period in the history of humanity. The international rule of law, as compared to the domestic rule of law, is in its adolescence. As we all know, adolescence is a transitional period marked by social change and challenges. We cannot therefore expect that the rule of law among nations displays all the maturity and solidity which we expect from it. It will experience challenges as it grows. It will occasionally suffer from shortcomings. It will be affected by strong headwinds in its progress, and this actually happens to be the case today. At present, we seem to find ourselves in such headwinds. Or to put it more philosophically, in an interregnum, a period of discontinuity in world history. 500 years after the first Europeans, led by the Portuguese, came through Mombasa and Malindi, seeking to conquer, to enslave, and to colonize the peoples of Africa and Asia, and to plunder their resources. The Italian philosopher and communist leader Antonio Gramsci, who wrote about such interregnums in which one world is dying and the new world struggles to be born, wisely observed that during such periods, and I quote, morbid phenomena of the most varied kind come to pass. Morbid phenomena of the most varied kind come to pass. We witnessed several morbid phenomena last year and this year, as far as the international legal order is concerned. To give you a few examples, we witnessed blatant and deliberate violations of the rules of international law in Gaza, the West Bank, Ukraine, Sudan, Syria, Lebanon, Venezuela, and most recently in Iran. No respect for sovereignty and territorial integrity, no respect for human rights and humanitarian law, no respect for the right of peoples to self-determination, and an attempt to engage again in resource imperialism and a rhetoric which glorifies colonialism and the conquest of foreign territories and countries. A manifest lack of respect for the fundamental principles of the UN Charter, including the prohibition of the threat or use of force, ignoring the rules of humanitarian law, flouting the sovereignty and territorial integrity of independent member states of the UN, denying the right of peoples to self-determination, and in some instances, their very right to existence have been evident in almost all these conflicts. This has been aggravated by the selective invocation of international law with respect only to certain conflicts, and more recently, by the statement is that the government of the United States did not feel constrained by international legal norms and rules. Above all, we saw some of those powers who helped forge the rule of law at the international level in the aftermath of the Second World War, because they suffered under that war, abandon those rules or refuse to apply them to their proteges or act as complicit bystanders, showing total indifference as they are blatantly violated. However, in my view, there is no reason for despair. The vitality of a legal order is for the long haul. There will always be periods of turbulence, but the dangers lurking behind those turbulences should convince states to stay the course, to uphold the rule of law, because the alternative is much less desirable. There is today an international legal order of a universal character, and the rules of international law have become a standard by which all the peoples and societies of the world assess the behavior and actions of governments wherever they may be. We are no longer in the West-centric or Eurocentric international law of the 19th or early 20th century, which allowed for colonization and the arbitrary use of force as policy instruments in international relations. The international rule of law belongs to us all today. The number of lawbreakers is also limited, and that is why also I said there is no reason to despair, because there is no widespread breaking of the law. Out of the 193 member states of the UN, it's only a handful that have gone rogue, however important may be their military or political weight. Here, the main risk actually lies in the number of silent bystanders who lack the courage or perhaps the conviction of standing up for rules to which they long claimed to subscribe and to uphold. Kenneth Roth, an American human rights advocate, recently wrote, and I quote him, that the US government has long considered international law to be what Lilliputians used to restrain Gulliver. You remember Gulliver's Travels and the Lilliputians. Apparently, Gulliver now wishes to shake off those restraints and crush the Lilliputians. What should the Lilliputians do? And of course, the third world, the global south, is part of those Lilliputians. Are they going to stand up for the international rule of law, or to lie low and silently nurse their wounds? Are they ready to reject the threat or use of force as a method of settling disputes? Are they ready to uphold the basic principles of the UN Charter, firmly and publicly? Or are they going to accept meekly a world in which, as Thucydides stated more than 1,000 years ago, the strong do what they can and the weak suffer what they must? If the guardrails of the international legal order are removed, the consequent chaos and lawlessness will affect all nations. Perhaps it will affect the weaker nations more, but the militarily powerful will not be spared either. It will sow the seeds of instability and anarchy and negatively impact on the lives of several generations. It will create conflicts and large-scale violences in various parts of the world. Force will determine whether states remain independent and sovereign and whether certain peoples actually will continue to exist as sovereign nations. The price of indulging the lawbreakers and of not being able to take a firm stand against their violations of the law today will gradually become too steep and will come to haunt all members of the international community. Not standing up for the international rule of law means consenting to the might is right doctrine and accepting the law of the jungle in international relations. Whenever power and military strength were allowed to dictate the laws of the world, and it has happened many times in the history of humanity, it always led, as I said earlier, to catastrophe, to disaster, and unacceptable levels of death and destruction. Of course, as the International Court of Justice said in one of its judgments, breaches of the law are neither capable of terminating a treaty nor of changing the content of the rules of customary international law. Likewise, a breach of international law cannot per se be characterized as a state practice capable of modifying the content of the law. So from the perspective of the court, if a state acts in a way that is incompatible with a recognized rule of law, but defends its conduct by appealing to exceptions or justifications contained within the rule itself, then whether or not the state's conduct is in fact justifiable on that basis, the significance of that attitude is to confirm rather than to weaken the rule. The question, however, arises: are the peoples and governments of Africa going to accept the return of resource imperialism and colonialism? Are they going to accept, again, a system which allows the powerful to take the spoils? Are they going to suffer under a system of might is right, or are they going to stand up for the rule of law, for independence, for territorial integrity, and for the equality of nations and equal rights of peoples? This is really the question today. The danger is that when states allege too often false exceptions or justifications to cover apparent breaches of international law, the edifice of the law built by humanity, generation after generation, risks to lose in clarity, certainty, and predictability. That is what is needed to be avoided by all means in the present circumstances. The clarity, certainty, and predictability of the law should not be put into doubt. It is the only way to ensure that peace among nations is fully preserved and the resort to the use of force in international relations is rejected. As you may recall, Dr. Bonaya Godana made the ultimate sacrifice while seeking to reestablish peace among communities and to ensure that the rule of law is upheld for the sake of the progress and development of those communities. These were his communities. It is in that spirit that we should confront the challenges facing today the international rule of law. If peace is to prevail among nations, it is imperative to preserve the integrity of the rule of law. Are we going to have a Bandung moment and to see the lawbreakers called to order in the same way that the leaders in Bandung in 1955 called the colonial powers to order? Or are African and Asian states going to submit to the will of the militarily powerful and accept again to become protectorates or even colonies whose resources are pillaged and whose peoples are oppressed? It is only the rule of law which can protect African peoples. It is only the rule of law at the international level and the upholding of the rule of law that can safeguard their interests. We are at a tipping point and in interregnum, as I said, in human history. One era is coming to an end and another is about to emerge. The nature of what will emerge depends on the actions taken today by the leaders of what the UN Charter calls the peace-loving nations. Those who oppose war, those who oppose imperialism and colonialism and do not want to go back to being dominated by foreign powers, and those who want to use their resources for the progress of their own people. However, they will have to stand up and act instantly. They must do it now. There is no time to waste. I thank you very much.
At this moment, I invite Mr. Humphrey Sipala to take over the Q&A session.
Thank you, Dr. Mbori. Again, Judge Yusuf, thank you so much for what is a magisterial recount of international law in the 20th century and what precious germs it gives us, and most importantly, rooting it in the Bandung Declaration and the spirit of Bandung. I'd like to ask you two quick questions. One about you and Dr. Bonaya Godana, and another about your own scholarship, and then we'll open the floor to the audience. Hearing you speak, Judge, about your friendship with Dr. Bonaya Godana. He needed French advice, you gave it to him. You thought about skiing, but he did more of it. And I'm reminded that it seems like your friendship operated almost like international custom. He was the usus, and you were the opinio juris. He did, and you thought it. Could you give us another anecdote about how that kind of friendship operated?
The second one.
Oh yeah, I could give the second one after. Go ahead, okay. The second question is related to your own reflections today in the lecture, but linking it to your very strident thoughts in your separate opinion in the climate change advisory opinion, which expresses a certain exasperation, and you could correct me. In fact, you do say that the court's non-cognizance of question B borders on the unreal. Would you say that continues to be the characteristic experience of the Global South since Bandung, I know today you've ended with a note of, upbeat note of expression of hope, but in your own experience, is that bordering on the unbelief, the overriding feeling of the Global South?
Thank you very much. And thanks a lot for these two questions. First of all, with respect to my friendship with Dr. Godana, it was a friendship which lasted for a very, very long time. And the examples I gave you were examples from our student years. But our friendship, of course, went beyond that period. And we were always in contact with each other while he was making his way here in Kenya, because he decided to come back to Kenya to continue his career. I decided to stay in Europe to continue my career in the UN system. But we continued to meet all the time, either here in Kenya or in international gatherings. And of course, whenever I was coming to Kenya, the first person I would call was Bonaya Godana. And his driver always called me, your brother is waiting for you, whenever he picked me at the airport. But as far as anecdotes are concerned, I was at the African Summit, African Union Summit in Algiers, representing UNIDO at the summit. And Bonaya Godana was there as the foreign minister of Kenya. And I was sitting where observers normally sit, which is behind the others in the meeting hall. And the foreign minister of Sierra Leone, whom I knew at the time also, passed by me and said, "What are you doing here? The seat is empty. Nobody is sitting there. You should come and represent Somalia." And I told him, no, I can't do that. And he said, no, I am going to say that publicly, that you are here and you should come and sit at the Somali seat, And he did that. Yeah, he did that. But Dr. Godana took the floor immediately and told him that, he didn't really resort to any formalities or legal rules that would prevent me from doing that. But he said, knowing Dr. Yusuf and his modesty and his humility, I'm quite sure that he will not occupy this seat. So please, do not embarrass him. So he really saved me from a very embarrassing situation. And I appreciated that very much. And I thanked him a lot for his friendship. Climate change, yes. Well, there are things which you would like to see, in a judgment if you are a judge. And I was perhaps the only or maybe one of a couple of judges who felt the effects of climate change directly, personally, because I see the drought in the Horn of Africa. I see our people is suffering every day. When I was growing up in Somalia, we had drought, but we had drought once every 10 years, once every 15 years. And people actually had names for those years of drought, and they could remember them all the way back to 100 years. But now it is almost every year that you have drought in the Horn of Africa, and that's due to climate change, and we have to accept that. And it is due to a phenomenon which we have not caused it. We have not contributed to it. And the best available science clearly affirms that we had little or nothing to do with global warming. It's not us, but we are suffering from it. And therefore, I did not like the fact that although the question of the UN General Assembly actually clearly indicated that there were two categories of states, one which significantly contributed to environmental harm through its actions and omissions, and another one which was particularly affected by those actions and omissions, the court did not want to refer to these two categories of states. And that is why I issued, and I thought that I would join to the judgment a strongly worded separate opinion. I thought that I should not really dissent because what the court said otherwise in general was going to be useful, especially to small island states, to least developed countries, to countries affected by climate change, and therefore I did not want to oppose it, but I thought I should express my opinion very clearly and say that there were certain aspects of the judgment with which I did not agree. Thank you.
Thank you, Judge. We'll open the floor. I should like to begin with a female voice. Oh, yes, there you go. So could you bring the mic to the fourth row? Just put your hand up, keep your hand up. Keep your hand up, yeah, the mic to her. And then a second. Okay, so we'll take those two to start.
Thank you so much. I'm Nabintu Wanchiko, a finalist in Kabarak Law School. And my question is on...
Could you please just speak up?
I'm Nabintu Wanchiko Leticia. And my question is on indigenous people's self-determination, because while you were speaking, for me it was like states, like global South state self-determination, and for me they are kind of different. And especially, how do you think the Bandung conference addresses the question of indigenous people's self-determination? In that state, international law, also domestic law, I've struggled to see the claim of indigenous people's self-determination as equal to the state one. And instead, they seek to integrate indigenous people in the state system. And this process of integration has resulted in their marginalization, genocide, and all that. Thank you.
Okay, we'll take the second question from this hand. If we could pass the mic there. But just to recap, Judge, Nabintu is asking, what is your thought about the self-determination of indigenous peoples in the context of the Bandung Declaration, the Bandung Spirit? Because from your lecture, your discourse was mostly about the states, yet indigenous peoples have a unique situation. Yes.
Good afternoon, Honorable Abdulqawi. Such an honor. My name is Ruth Jebet, and my question is that I note that one of the ways that the global South can stand against imperialism is pursuit of justice or recourse through the International Court of Justice. But as you've mentioned, one of most of these aggressor states not only attempt to weaponize these laws to justify their imperialism, but they also fail to comply with these laws. Then in that case, wouldn't the global South countries who are pursuing this form of venture be hitting a blank wall whereby they'll be receiving symbolic victories from the International Court of Justice? Or basically my question is, how can the enforcement mechanisms be strengthened? Thank you.
Again, she speaks about the problem of powerful states ignoring the directions and the statements, the pronouncements. And then it would mean that the states in the global South would be hitting a wall, and enjoying symbolic victories rather than substantive justice. So how can enforcement of these pronouncements be enhanced? You could respond to the two, and then we could take more questions.
Thank you very much. First of all, as far as the right of self-determination of indigenous peoples is concerned, the right of self-determination applies to all peoples, but it is in the law, it is in judicial decisions that we determine actually how such a right is to be exercised. The issue is not that the right exists. The issue is the application of the right and the exercise of the right, and in what context. For example, this right has been mainly exercised at the international level by colonized peoples in order to achieve independence. Now, once a country achieves independence and becomes a nation like Kenya, an independent state, do the peoples within Kenya have a right to self-determination, and to what extent can that right be exercised? This has actually been a subject of a number of judicial determinations. For example, before the African Commission of Human Rights, several cases came from African countries and from peoples in Africa, in Nigeria, from the DRC, of peoples claiming the right to self-determination within the state. Of course, there are different ways still of exercising the right to self-determination, but is it a right to self-determination to be exercised within the state and therefore to have, for example, education in the language of the indigenous people, exploitation of natural resources, or the right of the indigenous people to exploit and to have right to exploit the natural resources in their territory, etc. But still within the laws of the country and within the constitution of the country? Or is it a right to self-determination to secede from the state and to go out of the constitutional order? And the African Commission of Human Rights had in both cases said that the right of people to self-determination had to be exercised within the state and within the constitution of the state. And there was absolutely no such a right to secede, which would actually lead these peoples to secede from the state of which they were a part. But we know that, for example, under certain constitutions, like the Constitution of Ethiopia, the Constitution of Ethiopia acknowledges that there are peoples within the federal state of Ethiopia, and that these peoples may exercise their right to self-determination, they say, up to secession. But that is the Constitution which recognizes it, not the rule of law at the international level. So, because otherwise, international law would undermine the states themselves, and international law is not meant to undermine the states which exist, because international law is created by the states and is enforced by the states. But if the Constitution recognizes exercise up to secession, then of course this may be allowed. The second question was about, if you can repeat, please.
Essentially the efficacy of the pronouncements of international judicial bodies.
Yes, you know, the reason why the pronouncements of the Global South in the 1960s and 1970s became effective and actually contributed to the reform of international law and to the incorporation of third world perspectives, Asian, African, Latin American perspectives into international law, and the acknowledgement of their point of view was because they clearly expressed it. And they put forward proposals which they, all of them, supported. I was a young delegate to the Law of the Sea Conference, and there were two outstanding Kenyan international lawyers, Andy Adede and Francis Njega. And Andy Adede and Francis Njega, together with other lawyers from the third world, Africa, Asia, worked on the concept of the exclusive economic zone. And the Latin American countries came up with the concept of the patrimonial sea and put it forward to the conference. But the concept of the patrimonial sea, its scope and its rules were not acceptable to many countries, especially countries from the north and countries that had very powerful maritime fleets. So when the African group came up with the concept of the exclusive economic zone, the Asian group joined them, and then the Latin American also joined them. And that's why today, an idea which actually came from Kenya and came from Africa is part of international law and has become a norm of customary international law. The exclusive economic zone today is an essential part of the constitution of the oceans. So what the Asian, African countries and the third world countries, global south, need is to reinstate, rediscover that solidarity and to work together to bring ideas of this kind, substantive ideas, to the international arena. And I can assure you they will work.
Judge, allow us to take a second round of questions. This time, certainly, there was a hand up. Could you take your hand was up quite early. Yes, certainly. So please keep it straight and quick.
Yes, thank you so much. Hello, everyone. My name is Elvis Ongiri. I'm a final year student at Kabarak. And my question is, as a budding international lawyer, right, how much leeway do we have as young ones to become, as you put it, more innovative and not mainstream, more critical, especially thinking about how maybe in applying to master's programs and getting into certain opportunities, having a certain label can detract you. For me, it seems that it is only when you get to the highest level, say at your level or tenureship in a university, that's when you can actually speak your mind about your views on international law. That's my question. So how much leeway do we have? Thank you.
Well, I don't think that there is anything which limits your right to express yourself, whether you are an undergraduate student or a graduate student or a learned scholar. You should always feel free to express yourself freely. Of course, different people may take it differently, but it is extremely important that you should speak your mind. And that is the best way, actually, because it's all about honesty and integrity also. And if you hide your feelings, maybe, you are not being honest about your views. So don't be afraid of expressing your views. Do it.
One last question, Judge?
Yeah.
One more hand. The gentleman, Eric, is actually alumnus of Kabarak Law in the first class and has joined us here today. Eric.
Thank you. My name is Brian Awunda. I'm the senior most alumni of the School of Law. Briefly, before I ask my question on the Bandung Declaration, I'd just like to point out the kind of lawyer Kabarak has produced. I am the lead counsel in a petition by farmers. We have sued the government for complacency in fighting climate change. Judgment is coming up. Yesterday, I received instructions to stop Kenya Wildlife Services from exercising and relocating the animal orphanage. And I also conduct international moot court competitions in the first of its kind quasi-judicial environmental law platform. So that is what Kabarak has produced. My question is on the Bandung Declaration as well as the international rule of law. I find that two things weakened the international rule of law in matters Bandung Declaration. The first one was the global South countries were united by colonialism and did not share other national interests. So when colonialism was out of the picture, then national interests were differing, and which hindered the implementation of the Bandung. And also the Bandung Declaration failed to create an international permanent body or organization that would enforce the declaration. So what is your view on those two facets? Thank you.
Thank you very much. First of all, I think that you are right that they had a shared value at the time. You know, normally law reflects certain shared values, whether it is at the domestic level or at the international level. So you have to build the law on those shared values which are common to a certain society or community, you know. And without establishing and identifying those values, it is difficult actually to enforce law, because otherwise law will have to be enforced by force, because people are not convinced that it actually reflects their values, you know, and what they hold to be sacred or what they hold to be in the interest of their community, etc. So there were shared values at that time, and the shared value was the fight for independence, the fight for sovereignty, decolonization, and they were able to work together easily, you know. And that's why at the beginning it was only the Asian African countries, and then the Latin American countries did not join them. The Latin American countries joined them later when it came to sovereignty over resources, because the Latin American resources were also being plundered, although they were independent states, and there was gunboat diplomacy. You know, if you don't give me your resources, I'm going to send my gunboats and take them by force. This was what was happening in Latin America. And the Latin American countries in the 1950s tried to get the UN General Assembly to adopt on several occasions a resolution on the permanent sovereignty over natural resources. They could not get a majority. They were able to get a majority only after the independence of the Asian African countries in 1962. And that is when the resolution on the permanent sovereignty over natural resources was finally adopted. So you are right. And then, of course, divergence of interests came, but not only that, it is also divide and rule which came. Because in the late 70s, the northern countries started complaining at the General Assembly of the United Nations about the dictatorship of the majority. And the dictatorship of the majority was these three regions which banded together and were actually tabling resolutions, decisions to be adopted and to become part of international law. And therefore, of course, they started to divide them, to be able to tell them, you know, we are giving you aid, we are giving you this, we are going to talk to the International Monetary Fund, the World Bank to give you a loan, etc. And then we had the structural adjustment programs which became a condition for our development, you know, and actually led to the underdevelopment of many of the countries, or the perpetuation of the underdevelopment of many of the countries in Africa and Asia, etc. So there was division. You are quite right. So they will have to find other shared values, and they will have to work together in order to be able to stand up to the others. But today, they may actually be able to find even shared values with countries in Europe. Because what's happening in certain parts of Europe, you know, is also something which the Europeans had never experienced. And they are discovering now for the first time that if you are not protected by the rule of law, then you can actually suffer as the rest of the world has suffered for centuries. Thank you.
Thank you so much, Judge. It is time that we reluctantly must stop this conversation and look forward to another. Allow me to express sincere appreciation, almost a transgenerational appreciation from our students, and I think ourselves, faculty, to you for having taken your time. It has been a singular honor for us. Welcome. Thank you so much.